Today I'm going to talk about the importance of you testifying if in fact you decide you want to go forward with the trial. This is part 13 of our series on self-defense for need to know what, need to know the law. Dan McDermott here, McDermott Law Group, McDermott Mafia, McDermott Militia, all one of the same. Guys, the reason that this is so important is because generally speaking, in most criminally charged cases, most attorneys are going to tell their clients that they should not testify. You have the Fifth Amendment right, we've discussed this before, to remain silent, not just during the course of the arrest and when they're questioning you, but throughout the entire proceeding of your case. You don't even have to testify at trial. As a matter of fact, the judge is going to instruct the jury, if in fact you do not testify, that they cannot take that into consideration and use that against you when arriving at whatever their verdict might be. In other words, the judge is going to tell them that you have the absolute right to remain silent and you do not have to testify during the course of the case, and instead the state has to prove you guilty beyond a reasonable doubt. Something important in a self-defense matter, though, if you don't testify, the jury is not going to know your story. So instead, they're going to hear the prosecution's version of what occurred. They're going to hear all their witnesses talking about what you did and the fact that you shot your gun, for example, and they're not going to hear any reason from you as to why you shot your gun. For purposes of self-defense, you have to establish what's called a prima facie showing that there was some form of self-defense, which basically means if you can show through any evidence, which includes your own testimony, that you were scared, that you had to go ahead and defend yourself. Once there's some sort of anything that can be relied upon by the judge, by the jury, to determine, hey, this might be a case of self-defense, once there's that prima facie showing, then the state not only has the burden of proving you guilty beyond a reasonable doubt for the charges that have been brought against you, but they also have the burden of proving beyond a reasonable doubt that you did not defend yourself legally, okay? And this is important, but they can't establish that, you can't establish that without actually showing or actually sharing with the judge or the jury what your perspective of what occurred was. In other words, why did you have to defend yourself? Why did you shoot your gun, for example? And when you're going to do this, you're going to have to do this through testimony. In all probability, you're going to have to testify to be able to get your version of the story out. So why is this so significant? Because you're going to have to practice with your attorney your direct examination. Direct examination are those questions that the attorney asks his or her own client or his or her own witness under direct examination. So you're going to have to get familiar with the types of questions that are going to be asked, and you want to get familiar also with how you're supposed to answer those questions. That doesn't mean how you're supposed to lie about it. It's supposed to how you're supposed to answer these questions, because regardless of the fact that you're telling the truth, sometimes based on the way that you're answering the questions, it might not be a good way of answering those questions. So you have to be familiar with how you're supposed to answer those questions in the best possible way to be able to paint the best possible picture, to be able to show that this actually was an incident involving self-defense. And so for that very reason, I wanted to focus on this, because whomever is representing you, you want to make absolutely certain that that individual is very familiar with what your testimony is going to be, and that you have a very good idea of what type of questions he or she is going to be asking you during the course of the trial. I find this is one of the things that helps my clients out the absolute most during the course of a trial for a self-defense matter. Just wanted to share this with you for whatever it's worth. We're going to be winding up soon. I'll talk to you then.